Representative Nemus.
Good to see you, Judge.
Wanted to address was your question about what would be the legal problem. I did a little legal research yesterday. There's a long line of jurisprudence about the difference between judges in the Court of Justice setting how we run court. Of course, the legislature, it's one of my favorite things about being in the judicial branch. Your all's role is to set the laws, and we have no choice but to apply those laws. So you tell us there's a $10,000 amount in controversy that's going to be heard in small claims, we follow that. But we're the ones in the trenches in the courtroom seeing what happens every day. And we have made it work with these remote proceedings during the COVID time. But where you get in a problem constitutionally is because we are in the trenches, we do see what a defendant is going through when he enters a plea or when he's being sent to prison or when he or she is being probated. We are in the position to say what works and what doesn't. And so our opposition to this is we want to go through with the judges who sit in the courtrooms and watch these remote proceedings happening with our Supreme Court guidance to set the rules of how we run court. We're not saying we don't want to follow the legislative guidelines about the law, but this specific issue, when somebody has to be there, do they have to be there for an arraignment? Do they have to be there when they're being sentenced? Those are things that come out of the purview of this is a law and come more closer to a court procedural rule. So I think legally where you could be in trouble would be you have dictated a court rule, how court runs, rather than a law, what we apply, what we criminalize, how long you have to serve for that. Then the second issue would be the confrontation clause of both the state and federal constitutions. And what does that mean? And there's a whole line of jurisprudence about what it means to have a meaningful opportunity to appear in court. And in remote proceedings, while I can see you and you can see me, when quick issues come up during a plea that they need to confer or ask a question with their lawyer, there's no way to do that. And so even getting cases resolved, talk about cost savings, when we want to get a case resolved and we have to pass it 2 or 3 times because issues come up that weren't foreseen or a victim shows up and makes a statement, then we're passing a case more than we need to because we can't execute new paperwork, including a no contact order, including an order to go to mental health treatment. It causes delays that we're remote. And nobody's really talking about the additional delays. So I think the two-prong, one is letting the Court of Justice, who was in the trench with the people, look at what's best. And then the second prong is, are we really achieving the goals? And I understand we do work with all of our jailers. I work with Sheriff John Aubrey in Jefferson County. I consider them part of our justice team. But I think for this committee to consider dictating how this should run based upon what we've been through in this pandemic, rather than allowing our Supreme Court to promulgate rules that we operate by, and we're going to do it. Justice Keller sent out an email, and we know that we're going to go through that process. We would just ask this committee not to vote on this legislation now. Let us do it in a way that we know is constitutionally sound, that's sound to protect getting justice administered in the most efficient, cost-saving way, and not just jumping into this right now because we've been able to make it work somewhat during a pandemic. And I could go through anecdotally some stories for you, but
Judge, I don't mean to cut you off, but we really got to move on. Just for the record, though, I will say that the Commonwealth attorneys and the other people that were mentioned are also in the trenches. Representative Nemus.
Thank you, Mr. Chairman. I'm going to say something and then have a question, if I might. And I'm not looking for a response to the first thing I'm saying. I'm going to be the voice or the face of some of the frustration that legislators are feeling. Not looking for a response. That wouldn't be fair to put you on the spot. Let me say, first of all, that I was the director of AOC, the general counsel and chief of staff to the Supreme Court and the Office of the Chief Justice. And so I have a lot of respect for the courts and have fought for the prerogatives of the courts. We've heard earlier this session, we've heard today, that the court wouldn't deign to come into our business and tell us how to run our business. They've done that a lot. They've done that 3 times in recent memory. And again, this is me speaking, but please take it that a number of legislators express these frustrations constantly. Senate Bill 151 was not decided on its merits. It was decided on process. We had done that for a century. Every state had had that process and continues to have that process. Yet the Kentucky Supreme Court came into our business on process and says you may not do this. So to say that the Supreme Court doesn't come into our business is patently untrue. It would have been fine in legislators' view to knock that bill down if it were unconstitutional on the merits, on the substance. That's not what the court did. So to come and say we wouldn't come into your business is not right, is not true. The second case I want to mention, and again, not looking for a response unless you want to have one, is Marcy's Law. I don't care about Marcy's Law. The point of it is not Marcy's Law. Marcy's Law was passed in the exact same way that the judicial article was passed in 1976 that Chief Justice Palmore drafted. It was passed the same way that the Family Court Amendment was passed that Chief Justice Lambert drafted. It was because the court didn't like the result that they changed the process, changing what the legislature does in its processes. The third case is the one that gives us the most angst today, and that's the Acree decision from Franklin Circuit Court. This case, the Supreme Court said that the legislature has no role in making the law when there's emergencies. So when we hear we wouldn't deign to come into your business and talk about your process, that doesn't sit well with us. And this coming from a person who has fought for the prerogatives of the court system. So that's just something that I needed to say when I speak with my colleagues. Let's get to the point of this bill, if I might. I'm happy that Justice Keller is the head of the Criminal Rules Committee because Justice Keller is one of my two justices. She has Oldham County. I have a lot of faith in Justice Keller. My question to you guys, and I know Laurie Dudgeon speaking on behalf of the entire court, on behalf of Chief Justice Minton, I would like a commitment because I know the Criminal Rules Committee is defined by the criminal rules, who's on it. A lot of really good people. But who's not on it, or any legislators, and I'm not asking for us to be on it, but no legislators are on it, no members of CACO are on it, no sheriffs, no jailers, no prosecutors, no defense counsel. So what I would like, there are defense counsel, I'm sorry, and I think there's a prosecutor. But what I would like is I would like a commitment that on this question, not on the other criminal rules, because I understand that we shouldn't be in your process, although I wish you would understand a little bit more, you shouldn't be in ours. I would like a commitment that Representative Freeland and representatives from CACO, from the Sheriff's Association, from the Jailers Association, from the County Judges Association, will be particularly involved in the Supreme Court conference room when the Criminal Justice Committee meets on this question. Can I get a commitment for that? And if I can, what I'm going to suggest is that we pass out a committee and then we hold it and not have a floor vote. I've talked to the sponsor about this, and if we can get a commitment that Representative Freeland will be involved in the other organizations, then I think we can reach some kind of an agreement. Is that a commitment that the Court of Justice is willing to offer?
So while I can't speak specifically for Justice Keller, I can tell you what she told me yesterday, because we were speaking specifically about the fact that the jailers and the sheriffs were not on the Criminal Rules Committee and that there were a number of other stakeholders who she wanted to hear from. She committed to hearing from all the stakeholders, so I would imagine that she would absolutely be open to that.
And including Representative Freeland?
Yes,
okay.
Including, yes.
And I'll take that at face value, Justice.
I'll take this back to her, absolutely, and we'll be back in touch with you about that.
Yeah, I think Justice Keller is a person of honor, and I'm glad that she's the committee chairperson here, and I'll trust that. And so I'm going to vote yes in committee. Spoke with the sponsor, and I think what we're going to decide to do, I'll follow the sponsor's lead, but I think what we're going to decide to do is hold it for a vote this session with the commitment that's been made that Representative Freeland will be intimately involved in this question on the Criminal Rules Committee. Thank you, Mr. Chairman.
Thank you. And we have one more, and we've got to be super quick. Representative Mosier.
Thank you, Mr. Chair. I will be quick. I love this discussion. I've learned a lot. I think that everyone has made some really strong points. And, this is permissive language that allows for this to simply be an option in certain situations. Are there ever situations, I think we heard early on that, in the 1 or 2 minute arraignments or quick situations that this might be appropriate. I guess I'm a little confused why, I understand the process and that we need to have continuing discussions. But if we don't pass this bill, will this shut down virtual hearings? We're right. So the virtual hearings that are going on now will be allowed to continue while we have these discussions. Okay, well, I would just add that I agree with Representative Nemes that, if we have a commitment to continue these discussions, that maybe that's the appropriate.
And the court has in the interim continued to address that in each one of its orders that it's entered through COVID.
Mm-hmm. Perfect.
Representative Moser, we're still not allowed to have in-person court for the most part, and it's going to be months until we do.
Right.
So.
I didn't think so. Okay.
Thank you. We got to move on. So is there a motion on the bill?
A motion.
There's a motion and a second. There's no further discussion. So Madam Secretary, please call the roll. We did. Yeah, we adopted the sub.
Thank you, Representative.
Thank you.
Sorry. Representative Banta, thank you. Representative Blanton? Representative Bratcher?
Yes, I'd like to explain my vote. If there is an interim study on this issue, I hope that we also look at the timelines that the courts use. I mean, some of these Court of Appeal cases it takes 2 years to make a decision. That's frustration. That's not the work of the people, in my opinion. Sorry I got off. I vote yes.
Representative Cantrell?
I'm going to cast and explain a no vote. Virtual court appearances aren't going anywhere, and it's a good fit for many situations, both civil and criminal. Our courts still have a long way to go on this. They're not even using the same platforms, and they're not using them uniformly. However, there is a good framework in this bill for courts to adopt a similar procedure that's articulated in this bill, but they need to do it on their own. I've looked at KRS chapters 23A and 24A, which this proposed legislation is amending, and this legislation does not fit into the basic jurisdiction and fee issues that are covered in those chapters. Therefore, I believe it is stepping into controlling basic court operations, and we've heard the concerns about separation of powers and other constitutional concerns. Representative Freeland, I really want to thank you for your work on this bill, and I really appreciate your judge back home. I hope you can respect, though, that I had 2 judges here opposing this bill, and just like you had to do what your judge wanted you to do, I had to listen to what my judge wanted me to do, so I vote no.
Representative Decker?
Yes, explain my vote. I have judges for it, judges against it, attorneys for it, attorneys against it, so I'm going to pass.
Representative Elliott?
Aye.
Thank you. Representative Fisher?
I'll vote yes, subject to the understandings stated here.
Representative Heverin?
Yes.
Representative Kulkarni?
I'm going to pass today given the discussions and the testimony by the judges. Thank you.
Representative Lewis?
Explain my vote. I'm going to pass on this today. I was against the original version of the bill after speaking with my judges. The committee sub did make it certainly much more better, but they still have some concerns, and so I need to talk to them and research the bill more. Thank you, Representative, for your work.
Representative Maddox?
No.
Representative McCoy?
Yes.
Representative Minter?
Explain my no vote briefly. I share my colleague Representative Cantrell's concerns about this, and I think there's some serious questions about racial and social justice that have been raised by our presenters today, and our judges have made some excellent points. I do think we should study this in the interim, so it's a no.
Once in a while, yeah.
Representative Mosier?
Yes, as I explained, subject to further discussions.
Representative Petrie? Sorry.
He's got his mute on.
Representative Nemes?
Yes.
Thank you. Representative Scott?
No.
Representative Stevenson? Chairman Massey?
Yes. It's 9, right? Where's Petrie?
No.
Yeah, he's supposed to
Representative
go as
Petrie?
well. Can we hold it? Can we hold it and we can call it back?
No.
Chairman, we have a member
Right.
who is testifying in another committee, I believe.
2 of them.
Right, and so I know we're 1 vote short, and both of those votes were yes, and so I would hope that we could hold the vote open out of respect for those who are testifying in other committees, so they're allowed to vote.
We will do that. We'll come back to this after we hear the next 2 presentations.
Mr. Chairman, point of order. I don't think we can do that. I think our rules state you have to go through the roll call, and that the roll call vote is the outcome of the motion, and later votes cast. They can record votes, but they cannot affect the outcome of the roll call motion.
That's why we're holding it open, so that it's not concluded. And we can certainly alter the agenda and come back to it. So that's what we're going to do. So with that, thank you, Representative Freeland. Thank you, Ms. Hampton. And with that, Ms. Scott, if you could make your way down, you're on next, and we're going to hear House Bill 21. And I know that we have President Stivers here with us, and we're going to have some discussions about things that may or may not overlap. So I know that they wanted to hear each other's testimony. So, Ms. Scott, when the President, you can introduce yourself and your witness, and you may proceed. Bland, yeah.
Thank you, Chairman Massey and Vice Chairwoman Banta, for this opportunity to present House Bill 21 before the committee today. I have with me Dr. Pete Kraska. Dr. Kraska, if you would like to introduce yourself.
Hi, I'm Pete Kraska from Eastern Kentucky University. Good to see y'all.
Thank you. And Chairman, we may have another guest who joins us if he makes it in time, and I'm not sure, but we might have someone on video, but again, I'm not sure about that. Again, I represent Kentucky House District 41. I'm going to talk a little bit about Breonna Taylor. In just a few days, thousands of people in Louisville and across Kentucky and throughout our country will lift up her family and her community in prayer. Saturday, March 13th, 1 year. This is a hard week for a lot of us. I've said this before. Kentucky can be cruel to Black women, even in death. I said that on the floor when I spoke about Councilwoman Tanya C. Brooks, who passed away in December. We saw this in the response to Breonna's murder. She was immediately demonized. She wasn't allowed to be a victim. She was thrown under the bus and ran over by almost every facet of our society. And yet her family continued to be the biggest advocates for justice for Breonna Taylor. Much love to her mom, Miss Tamika Palmer, to her sister, Janiyah. She and my daughter, Shanti, graduated from middle school together. Much love to her aunt, Bianca. I attended church with their granddad until he passed away not too long ago. This is about family and community. Since March of 2020, Breonna's family has put themselves out here for public scrutiny as they've sought justice for their daughter, their sister, and their niece. In May of 2020, many of us caught up with the family and also put our bodies on the front lines for justice for Breonna. My life experience is different than everyone's here, just as yours is different from mine. And I've always found opportunities to learn from my colleagues who are from different places than I am. I often go home to West Louisville, where there are 19 chemical plants along the Rubbertown corridor, and talk about folks in Martin County not having clean drinking water or bathing water and how we can build together and take care of Kentucky together. Sometimes that's reciprocated. Sometimes it's not. I filed Breonna's Law in August of 2020 so that people would have plenty of time to tear the bill apart and provide good and important feedback. I didn't receive much legislative feedback except for the 15 people, some in this room, who signed on as co-sponsors. House Bill 21 is a reasonable measure. I wanted to present it to you during the interim so that we could have a conversation before the session began, but that did not happen. While the state FOP response to me filing Breonna's Law was fairly vicious initially, not the same for President Stivers' bill, Ryan Straw and I with the Kentucky State FOP have started conversations about the issues raised in House Bill 21. So we find ourselves here now, and you will hear more from Dr. Kraska about how his expertise contributed to creating House Bill 21. In the bill, you will find that we practically mirrored Breonna's Law that was passed unanimously in Louisville in June. In House Bill 21, we outlined law enforcement clearly announcing themselves. We outlined a 10-second waiting time before entering the premises. These are measures designed to keep law enforcement safe and the people who are in their homes. We outline the use of body-worn cameras to record serving a search warrant. Our bill includes mandatory alcohol and drug testing of officers who are involved in a deadly incident. We expect forklift operators to comply with mandatory alcohol and drug testing when they have an accident. My brother is a truck driver. He has random alcohol and drug testing as a truck driver, whether he's been in an accident or not. On the night that Breonna was killed, many of you probably know by now that there was no aid rendered to her. That's an issue that we have to address moving forward. These are all measures that are reasonable that you'll find in House Bill 21. I want to go ahead and turn it over to Dr. Kraska, who will discuss HB 21 in a little bit more detail and his role in bringing this bill forward. Dr. Kraska.
Thank you, Representative Scott. Thank you for having me. I'm honored to be here and to speak on behalf of this critical issue. Up until the late 1980s, the practice of no-knock drug warrants was unknown and almost non-existent. Today, U.S. police around the country conduct 60,000 of these a year. They've become normalized in the everyday operations of many police departments until tragedy strikes. Across the country, in all regions, and in large and small police departments, no-knock raids gone wrong have resulted in devastating consequences for both the police and the citizens they serve. These tragedies destroy families, ruin community trust, and oftentimes rock a police department to its core. I first encountered the tragic, unintended consequence of this practice in the year 2000, when the Modesto Police Department asked for my assistance in a particularly wrenching case. They were deeply unsettled by a drug raid that had gone wrong. After performing a forced dynamic entry on the father of a family's home who was wrongly suspected of dealing drugs, SWAT officers were securing the bedroom of 11-year-old Alberto. While Alberto complied with the officer's demand, it laid on his bedroom floor, waiting to be handcuffed, and in the chaos of these types of raids, the officer standing above him accidentally discharged his weapon into the boy's back, killing him. No drugs were found. The father had no criminal record. The surviving family won a $3 million lawsuit, and major reforms were put in place. This was in the year 2020. I've documented and studied hundreds of similar forced entry tragedies over the last 20 years since this incident. And the problem has shown no signs of abatement. In fact, numerous communities and municipalities just in the last few years have had to deal with the collateral damage caused by this practice. In fact, a lawsuit was filed against the Louisville Metro PD in October of 2019 for a botched no-knock drug raid in search of marijuana evidence. The family was getting their kids ready for school when the 14-member SWAT team breached the front door of their home, broke out windows, used flashbang devices, and held the parents and children at gunpoint. The occupants thought they were being robbed. No drugs were found. The family's attorney correctly stated that the situation created by the LMPD could have easily resulted in the death of a parent or child for no good reason. It was only 6 months later, on March 13th, 2020, that another forced entry drug raid in Louisville resulted in the killing of Breonna Taylor. The body of research on this issue has demonstrated unequivocally that the central and most common use of military hardware, technology, and tactics has been and remains today the surprised forced entry into people's homes, when typically a 10 to 30 officer tactical team breaks into their homes, often in the pre-dawn or late night hours, breaking and raking windows, detonating explosive devices designed to shock people into submission, and then conducting a search for drug evidence. These situations are highly risky for the police officers themselves especially when confronted with an armed citizen who thinks their dwelling is being broken into by a criminal. Perhaps one of the most confusing parts of this issue that I've certainly found over the last 7 months as I've been working with so many groups so closely about it is the following. The distinction between a no-knock warrant and a no-knock raid. Most no-knock raids are not conducted with a no-knock warrant. Most no-knock raids are not conducted with a no-knock warrant. And this cuts to the heart of what it takes to effectively address this issue. What happens instead is that many standard knock and announce warrants are carried out using the surprised forced entry tactic, the same tactic used when executing a no-knock warrant. Here's how that looks. A 10 to 20 officer drug tactical team or SWAT team approaches the residence quietly. They ready their breaching device at the front and or back door. They knock, announce, and breach the door nearly simultaneously. In other words, no-knock raids are almost indistinguishable in the field from police executing a no-knock warrant. A recent study conducted on drug warrant work in Kentucky found that teams of drug detectives routinely failed to follow knock and announce policies. Detectives instead would announce their presence in accordance with the battering ram hitting the door for the first time. This is why banning or restricting no-knock warrants without addressing the larger and as problematic practice as forced entries using a standard search warrant will not accomplish meaningful reforms. It is critical to recognize that key law enforcement experts acknowledge that the practice of surprised forced entry raids is a low-reward, high-risk endeavor. One person I work closely with is Mark Lomax. Mark is a retired police drug detective, and he's a tactical team member. He served as the director of the National Tactical Officers Association for 7 years, leading 40,000 SWAT officers. Mark says repeatedly to me, and he's adamant about this, and he said it publicly, that no-knock drug raids are not worth the risk. In fact, he says, quote, "We, the police, should not be in the business of rescuing drugs. It's just not worth the risk to us and the people we serve." Former Broward County Sheriff Scott Israel said recently in an interview, "I've always said entering a home should be an absolute last resort. Can you set up surveillance and get the person to leave the home? Anytime you can take a person down outside a home, just do it." Here in the Commonwealth, Kentucky Attorney Tom Wine recently said, "No amount of cocaine or marijuana or other drug or money from the sale of drugs is worth the life of one person like Breonna Taylor or a police officer." Fortunately, police experts and researchers do point to a simple alternative. Collect enough intelligence to make an arrest outside the person's home, and if more evidence is needed from their home, conduct the search warrant after the suspect is in police custody. The risks of creating such a uniquely dangerous situation for both police and citizens are not worth the rewards, especially if reasonable alternatives exist. Right now, there are 54 major state and local legislative bodies, Chicago, Pennsylvania, all over the country, 54 of them right now that have either passed or they're working on passing new laws that will address this problem. The bill we are discussing today includes many of the key features of these new laws, all of which are simple, constitutionally appropriate, and just plain common sense measures to ensure the safety and well-being of police officers and the citizens of the Commonwealth. These include, when executing a search warrant, the police must knock and announce their presence. Police should wait a reasonable amount of time for someone to answer the door. The warrant must authorize the police to conduct a forcible entry. Otherwise, they need to simply leave notice of the warrant on the resident's door. Search warrant executions need to be documented through the use of body cams. That's it. Other places are doing far more than this. They ban all nighttime raids. There's zero reason to do a raid at 1 o'clock, 2 o'clock, 3 o'clock, 4 o'clock in the morning. It creates really volatile, dangerous circumstances. They mandate the collection of data so we know what's going on. There's some transparency involved in this. And they limit the use of civil asset forfeiture in drug raids. Civil asset forfeiture is often the motivating force for getting inside people's residences. In other words, what you have in front of you is the minimum of what needs to happen. It is reasonable, measured, and very modest. And it is the least Kentucky needs to do. Finally, in conclusion, opinion polls conducted on this issue in the last month in Kentucky and across the nation find that the bulk of the electorate agree that the police should not be conducting surprised forced entry raids into people's homes. Their castles, if you will, unless it is for very serious crimes or dangerous situations and is therefore unavoidable. Notice I didn't say an outright ban. No one wants to prohibit the police from doing necessary policing. But as discussed, reasonable alternatives exist. This practice needs serious regulation. It is an extremely high-risk, low-reward endeavor. It destroys homes. It destroys people's sense of security. It destroys community trust. One of the things that bothers me about it in particularly is it destroys police legitimacy. But it also destroys the lives of beautiful people like Breonna Taylor. These raids are not worth the gain of a potential low-level drug arrest or the confiscation of some cash. What should matter most to any police department and those that guide them is the community's safety, trust, and sense of police legitimacy. No-knock raids, whether botched or routine, erode these pillars of effective policing and justice. Thank you.
Thank you, Dr. Kraska. And Chairman Massey, my third guest is here, if I could call him up. I'd like to call up former State Representative Charles Booker.
All right. I'll keep the mask on. I'm typically loud, but I'll try it's muffled. Good afternoon, former colleagues. I miss y'all. I actually have a heavy heart as I drove up here. I lost my granddad over the weekend, and some of you all may remember my hero, Sergeant Lindsey Hearn, that came to the floor, and you all applauded him for his service, and I thank you for that. I lost my other grandfather over the weekend, and it was hard to drive here, but he would have wanted me to be here. And I wanted to just lend my voice, give a little bit of clarity briefly, because I know you're pushed for time, to speak to why this bill is so important and why this moment is so important. I want to thank Representative Scott for drafting this and leading on this. I was actually pre-filing this myself during the summer, and learned that Rep. Scott was doing it as well. And I understood that black women don't have to get recognized in our state legislature. And so I wanted to support a black woman speaking for the life of a black woman that had been ignored. And so I wanted to rally behind her. And some of y'all probably followed me a little bit. You may have heard some noise I was making over the last year. I've been all over Kentucky, and I launched this organization, Hood to the Holler, which I'm president and founder of. And our aim was to show how we are all in this fight together, that we're family, we have common bonds, and if we lean into those, we can build a safer, more just, stronger Kentucky. And Breonna's Law, House Bill 21, speaks to that because it's an issue that happened to a black woman, but when her door was kicked in, everybody's door was kicked in. When her freedom was taken away, everybody's was. Because you could see her as a daughter, as a cousin, as a niece, as a friend, as a caretaker. And I wanted to help with this bill. And so I asked the people of Kentucky to join us in supporting the idea that everyone can be safe in their homes. And everybody responded. And when I mean everybody, from every single legislative district, from every corner of Kentucky, we had folks reach out to y'all. Y'all probably saw some emails. I won't apologize for that because that's democracy, but we had folks respond from every corner of Kentucky to say that they support this bill. And the reason why this bill is so important is because it was created by the community. The family, Ms. Palmer, I won't tell a story about Ms. Palmer now because I'm trying to keep it together, but this bill starts with an ordinance in Louisville. An ordinance passed to completely ban no-knock warrants, had unanimous support. The reason that happened is because the community was they were grieving in the streets. They were crying out. They were demanding justice, and they were demanding the freedom to be okay in their home. And because no one hears us otherwise, you know our history in Kentucky, if you don't listen to us, we're going to protest. We're going to stand on them tracks. We're going to march. We're going to lock arms. That's what we do in Kentucky. We fight back to take care of our home. And that's what folks did, and the leadership in Louisville responded. And so what we wanted to do at the state level is support the people. And so throughout the summer, the community came together to flush this out. The attorneys for the family was central to it. We had folks that were protesting, were saying, okay, how do we turn that into policy making? They got involved. So the bill that you all received came from the people. That's important. There are protests that are still happening because people still feel ignored, and they're devastated, they're traumatized, and people have lost a lot of hope. I'm not talking about just in Louisville, all over Kentucky. I went to places where I was the only person that looked like me, and everyone else was marching and saying we have to do something to honor Breonna Taylor. This bill is the one that does that because it speaks to the circumstances that set up the moment where her door was kicked in, bullets flew everywhere, hit her, and took her life away. And if we're trying to be accountable to her and to every Kentuckian, we need to support this bill. Now, I know that President Stivers is joining to support Senate Bill 4, and y'all got to realize how important this moment is. The reason that bill is coming is because the community spoke up. He wasn't thinking about this at the top of the year. This wasn't a priority because we're dealing with the pandemic. There's so many other things going on. The reason that we even thought to address this is because the community spoke up. So let's honor them. I think there are amendments that can come out of House Bill 21 to make Senate Bill 4 stronger. I think there's a chance to work together to do that. And I wanted to tell you all as a former colleague that I think that's the path that we can do if session's running short. Let's take this chance to work together and honor Breonna in a real way so that no one else has to deal with this pain. And the people of Kentucky can be proud and know that justice is coming and know that democracy means something. And thank you for letting me share my words.
Thank you, former State Representative Booker, for that. Chairman Massey, I will hand it back over to you to determine how you want to proceed. I know that Senate Bill 4 is the bill that the committee will be voting on. I don't know if you want us to field any questions or if you want to go to Senate Bill 4.
Thank you, Representative Scott. What I think I'd like to do is have President Stivers come forward and deliver his remarks, and then we can allow the committee to ask questions kind of together so that obviously both bills deal with no-knock warrants, and I think it would be more fruitful to do it that way. So with that, we'll let President Stivers come forward and take his place, and I know he wanted to hear your testimony. and he's done so now, and we'll let him proceed, and we'll see what he has to say.
Thank you, members of the committee and Mr. Chairman. I do want to take just a few minutes to explain some of the process of myself in getting involved in this issue. First of all, this is my 25th year in the legislature. Second, this is my 32nd year of practicing law. And I know many people walk into the arena of the legislature and say that, they've practiced law and been prosecutors. Well, I've actually tried 2 death penalty cases, one pled out in the middle. I've done multiple defenses and prosecutions in state and federal courts of large drug conspiracies that go beyond states and are even international. So I've done that in my 30-plus year career in the courtroom, having been on both sides of prosecution and defense. Looking at the situation that occurred with Miss Taylor, I felt that I was in a good position to reach out to individuals, both the defense bar, the prosecution bar, individuals that were involved in law enforcement, individuals who were involved in the litigation. And I've had numerous meetings over the period of time with virtually all those, either directly or through staff members. I'll also tell you this, and many of the things that the professor said I agree with, also relied on a 22-year-old son who is in what is called the White House Communications Agency. Had nothing to do with it, young Marine. And they are trained in hostage recapture and terrorist intervention. So my youngest is an individual who parallels the president when he travels. And his eye has quite an extensive security background. So he has probably about as much expertise because he is now also a firearms trainer for the military at age 22. So I talked to him about this. And he said, Dad, when you do a situation of securing a house, it is extremely dangerous, not only for the individuals, law enforcement, it is dangerous for the people inside, and it is dangerous for individuals who are around the area, because you need to be trained and well-trained at dealing with these situations. And that struck me. The other thing that happened was one night the governor called me and explained to me something that had happened with Mr. McAtee and Mr. McAtee losing his life. And it was early in the morning, and asked, what can we do to help? We set up a committee meeting that I think was a joint committee meeting that many of these members were present, where Keturah Herron and Metro Councilman David James testified to talk about the circumstances and situations. Shortly after that, I then said that I would come out and attempt to draft a bill that would deal with no-knock situations. Now, there is, and I truly appreciate Representative Scott's work in this area, and I don't think that we are seeking different outcomes. I think we are just looking at it from a different method. And that outcome is a fair and just society. So with that, Mr. Chairman and members of the committee, the first part of the bill talks about circumstances, the circumstances for which you could seek not just a no-knock search warrant, but a no-knock arrest warrant, a little bit broader and more in-depth than what House Bill 21 does. It sets out circumstances related to, and lawyers who have dealt with this, 439-3401, which is the violent offender statute, and evidentiary value of information that may be located related to one of those crimes that fall in what we call the violent offender statute. The other components, and I discussed this in Louisville with Mr. Aguilar, who I understand was one of the attorneys and involved in litigation for Ms. Taylor. Other circumstances that for those individuals who are from Bowling Green will remember there was a potential terrorist cell and potential biological or weapons of mass destruction. So those are the other incorporated statutes within the circumstances for which you could seek a no-knock arrest or search warrant, understanding the high value of the information which you are seeking to obtain. The second component is the process. What process should be in place? Because it is apparent on that tragic night for Ms. Taylor that there was a breakdown of process. So the process is the individuals who are seeking this shall get supervisory sign-off. And that supervisory sign-off then leads you to get review. And I understand there may be some amendments to this, and I'm very willing to work on amendments. You get supervisory review, and then you get review by the Commonwealth or County Attorney's Office or someone within that office to make sure it meets the necessary protocols of what would be prescribed by this statutory change. The next component of this is to take it to a circuit judge or a judge who will then read it, and as the lawyers in this group understand, in the form of a detached and neutral magistrate. They are the buffer for which we are kept from unreasonable search and seizure as provided by our state and federal constitution. If they don't, it can be referred to the Judicial Conduct Commission for review, which is only appropriate. Now, we don't set standards, and I appreciate Representative Nemus's discussion with the AOC earlier. We don't get into their conduct. It is for them to set, but it is grounds for a referral. Also, if it is not an e-warrant, the individual's name has to be legibly identified so you know what judge issued it. Because one of the problems I think you see in jurisdictions that have 10, 12, 15, and I think Jefferson County may have close to 30 judgeships, it's not identifiable which judge signed it, so you can see what judge issued. In the rural areas, it's not a big problem. There's only 4 judges in my county. As you know, Mr. Chairman, you probably know most of them. Might even be related to a few of them since you are originally, your family is from Clay County. So this is the process for obtaining. Circumstances, process for obtaining, then execution. Body cameras, individuals who are trained and identifiable that know and have knowledge about the execution of these, because I do not disagree. This is a dangerous situation for all people involved, either the officers, the surrounding public, or the individual, or the residents who may not even be the target of the warrant, or the individuals who may be in the house, or the building, or the structure. So they need to execute. And if they improperly execute, then there are remedies. Suppression of evidence. Suppression of evidence only in the criminal form of the proceedings, but not suppression if it is sought to be introduced in an investigatory hearing for sanctioning or punishment, or in a civil action to determine whether there is some type of compensation that is needed to recompense the individuals who were civilly wronged. With that, Mr. Chairman and members, there is one other sanction to that, besides the suppression and introduction at the various and appropriate stages of differing legal proceedings. If one knowingly falsifies the affidavit, which practicing lawyers know that the affidavit is really key and critical to the obtaining of the search warrant, because that gives you those circumstances for which you can seek a warrant. If they falsify that, they would be subject to perjury charges. Now, individuals have asked me why I did not create any further sanctioning provisions. In fact, I had this discussion last night with members on this committee. This is a warrant situation. Sanctioning and review of police conduct go well beyond obtaining and executing a search warrant. I have been very vocal about other situations that I'm aware of. The situation with the young children, with the LMPD, officers throughout the state who have exchanged favors for dismissals of prosecutions, an inappropriate and improper arrest that has nothing to do with the obtaining of a warrant. I felt it needed to be siloed. Senate Bill 80, which was passed and currently in your chamber by Danny Carroll, who is a retired officer. And when you talk to officers, there is one thing they will be consistent in. They do not want other bad officers in their ranks. So Senator Carroll has sent that over, that I think addresses many of the complaints that individuals had related to sanctions and punishments for numerous inappropriate conduct by officers. So I think between the two, it very much addresses many of the concerns. Lastly, I want to say this. My co-sponsors are quite broad in spectrum in political philosophy. Professor talked about your castle. That's why John Schickel co-sponsored it. Working with Gerald Neal and Reggie Thomas, two of my other members, they are very much about the process. Actually, some of the language that was used in this was done in collaboration with them. So I think we came out with a bill that was targeted at part of the situation that, to me, and in my opinion, under the circumstances, that which is guaranteed to us by the Constitution of the state and of the United States, that individuals are entitled to a presumption of innocence, to have right of counsel, if necessary, a jury, and to produce witnesses, and that jury be made up of members of your peers and community. This young lady was denied that and should not have been. Also want to say this. This is not something, and I heard the professor say this, this is an indictment of a situation and other things that have occurred. Police officers have a tough job, and the majority of officers are good, but there are always, as we see in any profession, people who do the wrong thing or make mistakes. And hopefully, when you think about this and where I have cut this off, there would have never been a warrant issued to search that night, that house that Breonna Taylor died in, because it would not have complied with this statute, because it was not within the realm of violent offender statutes, threats, terroristic activities, weapons of mass destruction, or biological weapons, because of exactly what the professor said. This is high risk. It is dangerous to everyone involved. To you, Mr. Chairman, members of the committee, Representative Scott, the individuals who have worked on this, truly I think this is a discussion that needs to be had, and I am open to questions and further discussions.
What I'm going to do at this time too is Representative Scott, if you want to come up to the far side of the table, we can take questions for both presenters. Obviously, the vote we will cast will be upon Senate Bill 4, as I indicated at the start of the meeting. But I certainly want to have the opportunity for everyone. This is an important issue for our state, for everyone to have an opportunity to ask questions. So, do we have questions?
Mr. Chairman, can I say this? We've had a couple of discussions, and actually something that I would look at Representative Scott about, I think she had some suggestions about maybe even in certain circumstances broadening the scope of, I think, sexual offenses, child pornography, child offenses. I am not in any way opposed to certain things like that. So I think we can have good discussions in the future, but I truly believe that the process needs to continue.
Yeah. Okay, first we have Representative Heverin.
I just want to thank both of you. I just want to comment, no questions. Thank you both for bringing this to a forefront in the General Assembly. It's been a very important conversation. As our former colleague, Charles Booker, mentioned, from the hood to the holler. I don't know if Litchfield has hollers, but I've been part of the 18th District conversation. And I just appreciate it. I really took some time this summer to learn more about no-knock warrants. It's something I had never encountered in any of my professional career. I met with police officers, I met with judges, I had conversations with my community, and I think that lends us a real opportunity as a legislator to learn more and to listen. I've always said I did not come up here to be a Republican or a Democrat. I came up here to do the right thing for Kentucky. And so thank you all for having these conversations. Thank you for bringing this to a vote today, Chairman. And thank you for the bipartisan conversation for both of you all.
I'll just respond to that and say I appreciate the comment, because even though there's a lot that President Stivers and I don't agree on, when we can come together to have conversations about important issues, we should. And for me, that's what we're trying to exhibit here today, is coming together to figure out how we come up with a good bill that will make a difference for the people of Kentucky, and so that the folks that I know I've been out on the front lines with will no longer feel ignored or silenced or forgotten. So thank you, Rep. Heverin, for that comment.
Next, we have Representative Bratcher.
Thank you. I thank both of you guys for this presentation today. You know, the most I know about cops is what I see on TV. I mean, I have a few friends in the district that are cops, but I've never even done one of the drive-arounds that they offer to legislators and other office holders. You know, I always thought that in every situation that you announced, that's what the TV shows had. You announce and then you barge in. And I got to tell you, on first blush of this story, when it first broke, I was thinking, if somebody came into my house at 1 o'clock in the morning, unannounced, they're going to get some resistance in my house. Now, here's the question. Two questions, really. Number one is, and this is for you too, Representative Scott and Senator. Before this ever happened, did you know that there was a no-knock situation? You might, because you're lawyers. But Representative Scott, before this ever became a situation, did you know that there was a no-knock procedure out there?
Yes, and the reason why I said that our life experiences are different is because they are. As a Black woman in this community and in this society, I can't live and not know that that is a reality for many of us. In fact, Dr. Kraska mentioned a family whose home had been broken into in 2019. That's in the district I serve, in the neighborhood that I grew up in, the Russell neighborhood of Louisville. So yes, I was aware, very aware.
I'm very aware of it. One of the first things I did when I got out of law school, there had been, in Clay County, I was asked to prepare an arrest warrant based on information obtained from another jurisdiction out of state for two individuals who were believed to have been involved in a double murder. and were stopping in Manchester for a period of time before they went to Florida. Aware of it through law school, but have actually practiced it as an assistant Commonwealth attorney because I was up at 4 o'clock that morning to make sure if anything happened, I was present for legal advice. That was my first real life experience, but over 30 years I've had more.
And the second question, sir. On this particular case, there's discrepancies on if they did announce. But this original was not a no-knock warrant. Is that correct?
I am not totally aware of the circumstances. What I do know about a no-knock raid for the purpose of obtaining information, evidence, or indicia of a drug crime or paraphernalia should not have been done by 1 o'clock in the morning. And I think the professor talked about this. I am really at a loss to understand why at 8 o'clock walking out the door, if they had some belief, reasonable and articulable suspicions, that they didn't do it that way. And again, I wasn't there. I don't know all the circumstances, but from what I know, and I'll say this, I do not believe that the FBI allows search warrants to be executed before 6 o'clock in the morning or after 9:30 without exceptional and extraordinary and exigent circumstances.
All right, next we have Representative Mentor.
I'd like to thank you both for your presentations. I'd like to thank Chairman Massey for making sure that Representative Scott was at the table today. I would have preferred to have seen SB 4 passed and coming to this committee and SB 21 passed through this committee, going to the floor, and then working all of this out through the reconciliation process later on. But that said, I'm really glad that we're having this conversation. And I have talked with law enforcement in my district. I have a brand new police chief, first black police chief in history of Warren County, and is very supportive of the idea of getting rid of no-knock warrants. My sheriff, who is doing an excellent job, also very committed to getting rid of no-knock warrants, and said, there's just not a reason to do this. So I'm glad we're starting this conversation in the committee today, and I look forward to working with both of you going forward to make sure that nobody loses their life to one of these warrants ever again. Thank you.
Next, we have Representative Banta.
Again, thank you both. I was curious, Senator Stivers, is there any, I was reading the amendments from Breonna's Law 21, and I really like the paramedic or emergency services being available close by for any no-knock that was, I was wondering if you had looked at that, thought of it, or if we could add it in an amendment.
Representative, I have. Correct me, was it 2 or 3 days ago? Monday. My time somewhat gets lost at this point of the session. On Monday, we discussed this. I reached out to individuals who have more knowledge about what the composition of these individuals are that have the training and expertise. They told me that when they perform these types and execute these types of, be it search warrants or arrest warrants, that generally 2 of their members are, I'm going to look at Representative Mosier, EMT certified. Am I right with that technical term? But if they are not, Representative Scott and I had this discussion Monday about if there is not that type of individual accessible, instead of being present, be on notification and in close proximity. If something does happen, I'm amenable to discuss that because I think we've all agreed this is a volatile situation, high risk type of conduct. And I'm not talking about improper conduct, but conduct that has lots of opportunities. And I'm going to agree with Representative Scott. I don't have the knowledge she has, and I'll never say that I can say I'll never will. So do I know it? No. Can I understand it? To a certain extent. So I've tried to be very measured in what I've done, and I don't think that in this type of situation, and it should be limited, as if you've heard from Representative Mentor. Not sure if Peanut Gaines is still down there or not.
He's not. We have a new sheriff. There's a new sheriff in town, as they say.
This is a very limited and narrow use of an investigative tool and should be dealt with that way.
Thank you.
Representative Kulkarni.
Thank you, Mr. Chair. I have a comment and a quick question. I want to talk a little bit about the events of this past summer in Louisville. And Representative Scott, I was there when you called several of us to come down and see what was happening at Injustice Square Park, to see the protesters assembled peaceably, exercising their constitutional rights. You had called us there just so we could see what was happening, see why people were gathered. I was there when you were released from jail. I was not there when you were arrested that night, but I was on the phone with attorneys, city, and law enforcement trying to figure out what we could do to help, how we could get you and Ashanti and Shamika and several others that were arrested with you out safe, especially given the COVID pandemic raging around you. I say all this because it's, I was there for a handful of moments, which really were your reality 24/7 for the past almost year now. And I think that all of that experience is reflected in this legislation that you've presented in House Bill 21, which I feel is carefully crafted, which is deliberate, and which is reasonable. You're not asking for a whole lot here in this bill. As the professor testified, there were maybe 4 or 5 primary points that are common to Breonna's Law type legislation that have been passed in 54 jurisdictions across the country. I know that you publicly and personally invited individuals and input from organizations and people based on your intention and your desire to make sure that there were no unintended consequences, to make sure that this bill was the best bill that we could present in order to ban no-knock warrants, or at least to limit their use in emergent circumstances that warranted them. I think it's unfortunate that House Bill 21 is for hearing only. I appreciate the chairman providing time for this discussion because I think it's a very, very important one. I just wanted to lift up the work that you've done over the past year and to reiterate the point that we would not be having this conversation if it was not for that work that you did and for the lives of the protesters and the fact that you yourself put your body on the line and Ashanti, your daughter, was right there with you. I think that the use of no-knock warrants in such a broad capacity is one of the many remnants and tactics and policies that were born out of the, disaster that we call the war on drugs, which we know now has basically been a war on poor, black and brown people. And I noticed, and I'll go right into my question here, that Senator Stivers, your bill does not limit that. So it does talk about the violent offender statute, but my understanding is that there are subsections in there corresponding to the use of no-knock warrants in situations involving drugs. Can you explain some of that? Because, we've heard from law enforcement, we've heard from the professor, we've heard from different stakeholders that, and that includes a Louisville SWAT officer who said there's no amount of dope that is worth an officer's life. So I want to make sure that we are really addressing the root cause of some of the violence, the unnecessary deaths, and destruction that have been caused by no-knock warrants, and how Senate Bill 4 addresses that specifically.
You may proceed.
Representative, I think what you're talking about is some of the, as I would say, aggravated penalties when you start with a certain level, then a second conviction, third conviction, fourth conviction, that may actually get you into that realm. The thought process on that is, first of all, you have an officer that I understand the graduated nature of the offenses, but that's why you have a whole series and levels of officer, supervisor, prosecutor, judge before you would go in on that type of a Class D felony because of graduated sanctions, because it is a third or fourth or fifth offense. That's the rationale of putting those safeguards in and the tiered structure of trying to obtain this. I cannot legislate all circumstances, nor can we legislate conduct. But I think one would be ill-advised to be an officer to do that, a supervisor to do that, a prosecutor to do that, or a judge who initially and ultimately reviews it to ask for either an arrest warrant or a search warrant based on those types of circumstances.
All right, we don't have any further questions. I'm going to make a couple of comments myself, and then I'll proceed to take, or we do have a question. Representative Mosier, then I'll make comments.
Thank you, Mr. Chair. I'll make this quick. I don't really have a question so much as a comment. I just want to thank you, Representative Scott. It's good to see you, Representative Booker, and Professor Pasca for being here, and then and giving voice to a really difficult situation and set of circumstances, certainly. And then Senator Stivers, thank you for elevating this issue. I think that this is a very thoughtful discussion, a very thoughtful piece of legislation, and it's a good starting point. And I appreciate that there will be ongoing conversations about perhaps looking at some of House Bill 21 and integrating some of the very thoughtful measures that you've discussed. I think the EMT provisions are reasonable, and so it sounds like there's still opportunities to continue these conversations. And you know, to Senator Stivers' point, sometimes, you know, and I'm probably the biggest advocate for drug treatment here and really, you know, understanding the underlying problems, but there are definitely times that drug crimes rise to a very violent situation. And so, you know, I mean, as much as we all want to say absolutely there is never a time for a no-knock warrant situation or barging into someone's home unannounced, I don't know. I'm not a law enforcement officer. I'm not a lawyer, so I don't know legally all of the ramifications of completely doing away with this. But I appreciate the very thoughtful conversation. So thank you both. Thank you all, and I look forward to moving this conversation forward.
Thank you, Representative Mosier. My comments will be brief too. I want to thank all the presenters. We knew this would be a meeting that would need some time. This was something that impacted all of us in Kentucky, certainly some more than others in the community that it happened. And I've said all along that sometimes we can only do so much as a General Assembly to address things when there's inherent problems that go on in the communities, including poverty, racism, things of that nature that we have to deal with. And this might deal with certain circumstances, but the culprit, the thing behind all of this are the other problems that we all have to work together to resolve. And I want to thank Representative Scott. We've had a discussion about that. I've mentioned in many meetings my position, having served on the board at the National Underground Railroad Freedom Center, about implicit bias. And the fact of the matter is we have biases we don't even know we have sometimes. And we have to get to the heart of those issues and deal with those issues. And while we have to deal with things like no-knock warrants and other areas of the law to deal with circumstances that arise, we've got to take a deeper look at those things as well. I want to thank both of you for the hard work you did on this. I know that we were all awaiting this discussion. Part of the reason that it happened the way it did is just the way it goes through the process and ultimately winds up in the committee. So thank you for your time and effort on that. I don't see any other comments. So, Madam Secretary, if you would please call the roll regarding Senate Bill 4.
Do we have a motion?
Motion.
Now I would ask that you please call the roll.
Just a second. Who said second? I'm sorry. Thank you, Heverin.
Yes, I'd like to explain my vote. I want to vote yes because I'm excited about this moving forward, but I'd also like to see some more ideas from 21 kind of amended onto it, particularly the paramedics and things that don't interfere with the police. Thank you.
Representative Blanton.
Explain my vote, Mr. Chair.
Yes.
I'm going to vote aye today to move this bill forward. I've been working with Senator Stivers, and we'll continue to work on some amendments that we feel will make it even a better piece of legislation. So today I vote aye.
Representative Bratcher.
Yes.
Representative Cantrell.
I'm going to cast and explain a yes vote. The primary reason that I'm casting and explaining a yes vote is I tend to agree with President Stivers that had this piece of legislation been in statute, that the raid that took place that resulted in the death of Breonna Taylor would not have been authorized, and I can't say no to that. The other reason I want to say yes and explain my vote is because I want to join in some of the goodwill that's being offered here and say, you know, to Representative Scott and President Stivers, please continue working together. This has resulted in a better process and better piece of legislation because of your collaboration, and please don't let that collaboration end just because this bill passes committee or whatever happens after that. Please talk to each other about amendments and listen to the conversation that's been had today and carry that forward. Thank you.
Representative Decker.
Yes, and thank you for your work.
Representative Elliott.
Yes.
Thank you. Representative Fisher.
Yes.
Representative Heverin.
Yes.
Representative Kulkarni.
Briefly explain, Mr. Chairman.
Yes.
I'm going to pass today. I appreciate the work that both of you have done, especially Senator Stivers, and I'm going to reserve my right to vote yes based on any amendments that come out of your continuing conversation.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative McCoy.
Yes.
Representative Minter.
Briefly explain my vote, please. I'm going to pass today and reserve the right to vote yes on the floor. This conversation that we're having today represents the best of what this body can be. We're standing up for justice. We're working together across the aisle to actively solve problems in both chambers. And I would love to see some of these reasonable amendments that Representative Scott is proposing get on this bill going forward. But I look forward to being a yes on the floor if that happens. And again, let this be the beginning of 1,000 good conversations between the two of you about how we make sure there's justice for all in this Commonwealth. Thank you.
Representative Mosier.
Yes.
Representative Nemes.
Yes.
Representative Petrie.
I'm yes for the committee vote, but I have a few further questions for the sponsor on the procedurals issues, and yes for today, but reserve on the floor. Thank you.
Thank you. Representative Scott.
Senator Stivers and I have had many conversations. I'm going to pass as we continue to work on the amendments and reserve the right to vote yes on the floor. Thank you.
Representative Stevenson.
Explain my vote. I'm going to pass with the hope that we can have amendments that addresses both.
Chairman Massey.
Yes. With 15 yes votes, 0 no votes, and 4 passes, Senate Bill 4 is adopted and will be reported with favorable expression that the same should pass. Thank you, everyone, for your time. We have another matter to address. Yes, sir. Representative Blanton.
Mr. Chairman, I've been in Senate committee testifying on a bill. I would like to register a vote on 551.
Yeah, I was just getting ready to call that. We held that vote open, so we have 3 people to cast votes on that. Representative
Chairman,
Blanton.
can I go?
You can go. Thank you, President
Chairman and
Stivers.
members of the committee.
Thank you. Representative Blanton.
I vote aye.
Representative Petrie.
Thank you, Mr. Chairman. I'll register a vote on 551 of yes.
And Representative Stevenson. Okay. All right. So with regards to House Bill 551, there being 11 yes votes, 5 no votes, and 3 pass, House Bill 551 is adopted and with favorable expression that the same should pass, as amended by the committee sub. And everyone, thank you for your time. We are, for the committee's purposes, scheduled to have a meeting on Monday the 15th at 11.